get ready to be appalled. A Court of Appeals judge maintains that when it comes to abortion, the right of a doctor to not be offended is more important than the right of a woman. Here's what happened. So the 11th Circuit Court of Appeals has issued a decision regarding mifepristone, the pill that is used for medication abortion, stating that the pill cannot be prescribed after 7 weeks or via telemedicine. But that part of the decision is not what I'm here to talk about today. What I want to focus on is what this guy said in that decision. His name is James Ho, and he's a judge for the 11th Circuit Court of Appeals. Now, before I tell you what Judge Ho wrote in his opinion, it's important to point out that, number one, he was appointed by Trump in 2017. Number two, he's a member of the Federalist Society. If you don't know what the Federalist Society is, let me know. I'll do a separate video about it. Number three, he's a former clerk of the Supreme Court under Justice Clarence Thomas. Now, Judge Ho decided to include his partially dissenting opinion in this decision, stating that he agrees with the overall decision, but disagrees with the fact that the bench forgot to include, in his opinion, one important element. And that important element is right here. I'm going to read you what Judge Ho wrote. Unborn babies are a source of profound joy for those who view them. Expectant parents eagerly share ultrasound photos with loved ones. Friends and family cheer at the sight of an unborn child. Doctors delight in working with their unborn patients and experience an aesthetic injury when they are aborted. I'm oversimplifying, but an aesthetic injury is basically the damage that is legally relevant and somebody suffers when they were looking at something that they liked and now they can't look at it anymore. And to prove his point, Judge Ho uses this case, Sierra Club v. Morton. In it, in the 1970s, the Supreme Court established that certain mining permits violated other people's rights to enjoy the views and the natural wonders of the Sequoia National Forest. And that logic is used by Judge Ho to argue that a doctor has a reasonable, legally protected expectation to continue enjoying looking at a baby through an ultrasound and not be deprived of it. Let me be more clear. In this statement, Judge Ho states that the right of a doctor to enjoy looking at an ultrasound is more compelling than the right of a woman to decide whether or not to continue a pregnancy. Yes, a fetus is seen as a sunset or a sequoia that allows anyone, except for the woman, of course, to claim rights against it. I also want to underline how Judge Ho defines a fetus in his decision, calling it an unborn child, an unborn life, or an unborn patient. The woman and her interests, in this opinion, have completely disappeared. Ladies and gentlemen, for years we've theorized that some see women as objects and chattel. Sadly, in a post-Dobbs v. Jackson courtroom, the judges are able to say the quiet part out loud.